Mediators are experts in trying to seek resolution. And one of the ways you can best use the mediation process is being aware that there is someone out there who may have specific expertise in problem resolution and has now developed at least some awareness and some expertise in your client's specific problem, who has ideas that you and the client haven't thought of and that the other side has not necessarily thought of. If you're stuck, if you're looking for other solutions, if you're looking at other alternatives, ask the mediator.
We may be in a difficult position, but it occurs to me that there may be something that she wants and needs that isn't money that might help get this done. I don't know what it is. My client would never offer an apology, but my client might be able to say something conciliatory. Also, it might be a conversation worth having, and for her lawyer, if he's thoughtful and introspective, to maybe talk to her, because we all know these cases are about emotion as well as money. And she was fired. Feels terrible. Maybe there's something we could do that isn't economic.
No one is bound to accept what the mediator suggests. The mediator's there to try to help people reach the resolution that they themselves are struggling with. Who among us has not had an opportunity to have a friend or a colleague suggest something that you hadn't thought of yourself? We know that that is valuable when friends, family, and colleagues do it. It can be equally valuable when a mediator does it. Use the strength of their experience. The mediator is likely to be heard by everyone in the room differently than the advocates or the parties. You can use that to your advantage. Sometimes there are things that might be said or asked for, offers that might be made, ideas that might be shared, thoughts that might be aired, that simply sound different coming from the mediator than they would coming from the party. If that's important, use the mediator for exactly that purpose. If there's something that the other side needs to hear or know, whether it's an offer, a proposal, a suggestion, a question, but that would come off better and read differently when it was heard from a neutral rather than when it was heard from a party or the party's advocate.
The problem is that as things stand now, they're near the end, and if they keep going up, they don't know where it's going to end. So they're afraid of overextending themselves for no purpose. But if you were to suggest a number that, even though much higher than what they think they can pay now, you could assure us would do it, or you think would do it, that might help me push my client along.
Ask the mediator to pose the question, state the information, make the offer, explain what needs explaining, because it's going to register differently when it comes from the mediator, and that is exactly what the mediator is trained to do and available to you for.
You know, Mr. Mediator, we know each other pretty well, and you know that lawyers game the mediators all the time. They're not honest with the mediators, and since we know each other, you will believe me when I say that my client has authorized me to offer $175, but not to do it directly. They will not offer $175 because that might not be the end. I'm telling you that they will pay $175, but I'm asking you if you can find a way to get this case to resolve at that number and no higher. And I'm suggesting the way to do it is to make it your proposal and not attributing it to us. Is that something you could do? So what I'm saying, Mr. Mediator, is to be very specific. It is not our bid. It's your proposal. To put it another way, the same words from me for my client will be understood differently than if those words are said by you. So if I say, my client is prepared to settle this case for $175,000 today, you can say exactly the same words, but no one will assume that you're negotiating. It's your evaluation at where the case can settle. It's not a position.